Another common question that people come across when they're thinking of filing a lawsuit is, which court is the right court for me to file in? This is particularly important because if you file your case in the wrong court, that court may throw your case out or dismiss it, and then you will have to go and file in the correct court for your case. Something that can happen in between when you filed in the wrong court and when you file in the right court is your statute of limitations time limit may run out, which could be crucial to your case. When you're trying to figure out which court to file in, there are two main considerations to think about. You're going to think about which court is the right court for you based on your situation or the type of case that you have and where it is. The other consideration will be the subject matter at issue in your case. For example, is it a small claims matter, is it a probate matter, or is it a civil matter? I'm going to give you some examples of different courts based on the subject matter of the case. Currently in California, cases where you are asking for less than $7,500 are to be filed in small claims court. Similarly, larger cases that are over $25,000 being requested should be filed in civil unlimited court. In between these two, cases that are for more than $7,500 and less than $25,000 will be filed in civil limited court. There is also probate court for guardianships, conservatorships, and probating estates, and there is family court for divorces, custody, visitation, and paternity issues. There is an excellent resource available through the California Department of Consumer Affairs which can help you figure out which court is the right court for you. Keep in mind that there are some particular special claims that cannot be filed in the California trial court system. For example, government agencies require that you file a claim with the agency first before filing in a trial court. Similarly, federal claims or cases based on federal law need to be filed in federal court. Before you file, there are a few things you want to make sure you have done. First, you want to make sure that you have talked to the other party, the one who you are about to file a case against. There could be a misunderstanding or a simple solution to your case that would allow you to resolve it without filing in court. Maybe they were unaware of the situation, or maybe there is a simple solution that can be worked out between the two of you. Make sure that you have discussed this with them before filing a case in court. It will save you a lot of time and energy on a court case. Before you file a case in court, you will need to have some papers prepared. These papers are the papers that you will take to the court, and they are the papers that will begin your court case. For a general civil case, you are going to need to be prepared to file 4 things. First, you will need a complaint. The complaint is what tells the other party what your claims are and what you're asking the court to order them to do. You will also need a civil case cover sheet in many cases to tell the court what type of case it is that you are filing. You will also need a summons. The summons is the document that tells the other party that they are being sued. Lastly, you will need to be prepared to pay a filing fee when you file your papers with the court. In a family or probate case, the paperwork to begin your case will be slightly different. You will need to be prepared with 3 items. You will need a petition, which is similar to a complaint in that it lets the court and the other party know what you are asking the court to order. You will again need a copy of a summons, which will tell the other party that a case has been started against them. Finally, you will need to be prepared to pay a filing fee when you file this paperwork with the court. Depending on what type of case you're filing, you may need to draft pleadings or use judicial counsel forms to start your case. Keep in mind, the filing fee that you will be asked to pay will vary depending on the type of case you are filing and the amount in dispute in your case. There will also be additional fees throughout your case for motions and some other filings through the course of your litigation. So be prepared each time you file paperwork with the court. After you have filed your lawsuit, you will need to serve the other party in your case. That means the other party in your case needs to receive a copy of the paperwork that you filed with the court. All of the paperwork that you file with the court throughout your case will need to be served to the other party. There are several ways that you can serve paperwork to the other party in your case. One way is personal service. With personal service, someone who's over 18 hands a copy of the paperwork to the other person in the case. The second type of service is substituted service, when someone hands a copy of the paperwork to someone other than the other party in your case, and then mails a copy to the other party in your case. The third type of service is service by mail. You'll need to check your local rules to make sure that the type of paperwork you are about to serve is paperwork that can be served by mail. If it is, then a copy of the paperwork can be mailed to the other party in your case by someone else who is over 18. The fourth type of service is service by publication. In order to use service by publication, you need to have the court's permission in advance. You'll need to show the court that you have tried to serve the other party through one of the other types of service and have not been able to successfully serve them. If the court feels that you have tried enough, they will give you permission to serve by publication. That would mean you would need to take your paperwork and have it published in a newspaper that the other party is likely to read. When you're thinking about serving the other party, if you have any concerns about serving it or having it served by someone you know, consider hiring a professional process server to serve the papers. They are familiar with how to serve, and they do it frequently. For more information on how to serve, you should consult the Code of Civil Procedure.